part one of our viewer's guide to the healthcare arguments, where we provide you, the viewer, with an explanation of the Obamacare issues pending before the Supreme Court. Joining us to discuss the issue involving the Anti-Injunction Act is Nadine Strossen. She is a constitutional law professor at New York Law School. Welcome, Nadine. Thank you for joining us today.
I'm so glad to be here, Spencer.
So as you know, there are several challenges pending before the Supreme Court, but before the court can decide any of those challenges, make a determination as to any one of them, they must first decide whether this case is ripe for review. So what role does the Anti-Injunction Act play in making that determination?
This is a statute, Spencer, that governs the timing of whenever there can be or not be a challenge to a tax law. And I think the reason behind the law makes a lot of sense. Given that the government cannot operate without being able to efficiently and promptly collect taxes, the law provides that if you have a dispute about a tax that's being assessed on you, you have to pay the tax first and then sue for a refund later.
So it doesn't want the lawsuit to prevent the IRS from collecting tax revenues. Well, now, when you say tax law, I think a lot of folks at home are
what does this have to do with the health care
law? Exactly. But so tell us why aspects of Obamacare might actually be a tax.
Because the central provision of the new health care law, which most people call the individual mandate, the minimum coverage provision, the way that that is enforced is through a penalty that is enforced under the Internal Revenue Tax Code.
So it's written into the federal code then?
Yes, it is. And the penalty is assessed as you report your income taxes. And the law actually provides, the health care law provides, that the same collection and assessment methods are used for collecting this penalty for failure to comply with the individual mandate requirement as would be enforced under a general tax law. So that is the argument that this should be treated as a tax, and therefore you wouldn't be able to litigate the constitutional issues about the health care law until, number one, the individual mandate went into effect, which doesn't happen until 2014, and number two, that a penalty is assessed for failing to comply with it, which doesn't happen until 2015.
Yes.
So it's not surprising, given that huge delay that would be required, that even the U.S. government, which had initially raised this as a defense, saying, you know, this litigation is premature, we have to wait until 2015, the U.S. government has now abandoned that position.
Wow. Well, and I want to get to that in a second, but, I mean, isn't a penalty different from a tax? Aren't taxes used to raise money?
Well, it depends. First of all, some revenue is generated as a result of the penalties. That's been, computed by analysts who are looking at the economic ramifications of the new health care law. Secondly, a lot of taxes serve regulatory purposes. So the name and the label and the location in the Internal Revenue Code are all relevant but not determinative. And so one of the arguments that's being made, though, is if you look at the legislative history, Congress was very careful.
Because words matter. And when Congress knows the difference between a tax and a penalty. So, I mean, from the law, is it clear what they intended?
Well, it depends. Maybe they knew that it was functioning as a tax, but just wanted to avoid that politically very unpopular label. And that's something courts are very careful to not be blinded by formulas and labels, but look at how it is actually functioning. That said, I think there is a very strong argument. Not surprisingly, most of the lower court judges that have reached this issue have agreed that this really should be considered a penalty and not a tax.
Okay, so you mentioned the lower courts are split on the issue.
Yes, they are.
Even though some of them have agreed. And you were talking earlier about the Obama administration. So where do they stand here?
It has flip-flopped on this issue. Initially, it was arguing that, yes, the court should delay hearing because of the constitutional issues, because the Anti-Injunction Act. They switched their position, and therefore, since none of the parties that are involved in the case, they all agree that the Anti-Injunction Act should not delay the constitutional issues. Therefore, the Supreme Court did what it often does in this kind of situation. It appointed an outside lawyer, a Washington lawyer from a major Washington firm, as what's called an amicus, or friend of the court to make the arguments that the Anti-Injunction Act should, in fact, delay this litigation. And I read that brief, and it's a very persuasive job.
Really?
It raises. I'm not saying it would. I'm not saying it should prevail, but they do. They make the best plausible arguments that they should, which is that the language of the Anti-Injunction Act is written extremely broadly, and there's also a concern that we have to take this seriously as a limit on the power of the courts.
All right. Well, we're going to have to leave it there, but thanks very much, Nadine, for sharing your insight with us on this particular issue.
My pleasure.
Nadine Strossen of New York Law School. Stay tuned for the next installment of our series. But in the meantime, for more information on this or other topics, log on now to BloombergLaw.com, and you can follow us at Spencer Mazyck on Twitter. Bye, everybody.